Carol, you're the chair of the Alliance.
Yes, I am.
Can I invite you to speak to your submission?
Thank you. I am a forgotten Australian, a survivor of the out-of-home care system of the last century. I spent all but a few months of my first 15 years in care. I now work alongside other survivors and others committed to advocate for the needs of the many who still suffer enormously today from this childhood. All benefit from AFA's interests in the issues and its expertise from the lived experience of its members and its participation in multiple government inquiries. I am privileged to be asked to be here today and recognise the huge responsibility to the many thousands of forgotten Australians who have not had this opportunity. AFA's response to the questions posed in this consultation paper are based on the following three principles. Forgotten Australians must not be overlooked any longer. They must be seen and understood, with their history recognised and the circumstances of their childhoods and the impacts understood. Action must be swift and decisive to demonstrate this recognition and support for forgotten Australians to live the best possible life in their remaining years. Survivors of all forms of institutional abuse must be supported, not only those who experienced sexual abuse. The impact of institutional abuse on children, regardless of whether there was an overlay of other forms of abuse, which add immeasurably to their vulnerability, are now well documented. We need to go no further than the 2004 Senate report and the thousands of private sessions stories that the commissioners have listened to. Even without the devastating and compounding overlay of sexual, physical and emotional abuse, the facts remain that children brought up in institutional care suffered loss of family, loss of identity, face issues of esteem and other dimensions of harm, such as diminished trust, shame, guilt and humiliation. And that's not mentioning matters of lack of education and life opportunities. I note the directive, as stated in the terms of reference, does enable the Commission to go beyond the scope of separating out childhood sexual abuse from other forms of abuse as an eligibility requirement of redress. A redress scheme must take account of all the institutional experiences of hundreds of thousands of children brought up in this form of out-of-home care in the 20th century. Compounding these matters remains the issue of access to records. Accessibility and transparency of records access remains at best patchy across Australia. Some states do it better than others, but we are still struggling to get a consistent and transparent response from all the jurisdictions. To roadblock record access perpetuates system abuse. Redress for forgotten Australians must actively involve the institution in whose care the abuses occurred, including government, church and non-government organisations. And this involvement must occur to a degree that provides a financial incentive to prevent further abuse. Existing specialist support services for forgotten Australians must be resourced on a long-term basis to maintain the trust they have earned from people who have repeatedly been let down. State and territory governments must be held publicly accountable for the failures of their role in institutional care. The National Apology notes the failure of governments and their proxies. The consultation paper suggests that redress should consist of three elements: a meaningful apology from the institution if the survivor wishes, lifetime access to therapeutic counselling, monetary payment that recognises the wrong the survivor has suffered. The elements recognise the importance of a range of redress responses. However, they fail to consider other supports that need to be provided alongside the counselling and psychological care, such as priority access to medical and dental assistance. Page 9 of the executive summary asserts that elements of appropriate redress appear to be direct personal response, therapeutic counselling and monetary payments. However, the detailed discussion of this issue in the body of the consultation paper does in fact note the international support through the UN of the inclusion of legal and social services are part of a robust set of principles and guidelines for remedies for people affected by violations of their human rights. It notes the principles for remedy for victims of violation of human rights include rehabilitation, should include medical and psychological care, as well as legal and social services. All advocacy and support groups note with great regret and dismay the Australian government's essentially negative and almost dismissive response to the establishment of a national redress scheme, which was raised in the consultation paper. Just as the national apologies were bipartisan, we now call on both sides of the national parliament to make a national redress scheme a bipartisan matter. Thank you.
Thank you, Ms. Carr.
Thank you. Can I just raise a couple of issues with you? Firstly, in your submission, which deals precisely with each of the questions, we're grateful for that, you seek a recommendation that any person who was resident in an institution and report suffering as a result should receive at least $10,000. Now, I'm not clear as to what you contemplate being within the word suffering. Can you help me there?
Well, many forgotten Australians have told us of all forms of suffering in an institution. Being separated from family is a huge suffering, you know, it's a huge, or a lack of education. People suffer today from medical issues that happened because they were forced into labour, you know, child labour, before their bones were, you know, cemented. Or so lots of people have lots of different issues, and I think just being locked up in an institution is an abuse.
How many people do you think might qualify for that $10,000? You know, we've attempted to estimate how many might be eligible for redress if they were sexually abused, but what should we think of as the number that might fit into an expanded category?
Well, it was the Senate inquiry that said 500,000 children, you know, experience some form of out-of-home care. So not everyone would be still alive, of course, but no, the numbers would be big. Yes.
Yes, hundreds of thousands.
But given that some of the states have had a redress scheme which paid probably more than the $10,000 that we're talking as a minimum, those people probably would not be eligible for this scheme. Yeah. It'd be states like New South Wales and Victoria that have done very little.
Yes, and I noticed that your submission accepts that prior payments should be brought into account.
Absolutely.
In any redress
yes.
scheme. You've heard today at least, and no doubt many times before, of the value that's said to be there for a survivor if they sign a deed of release, if they're given a redress payment, and it's said to be finality. Now, I know your submission says there should not be a release,
Yes.
What do you say to those who suggest that the survivor benefits from finality?
I think the church or the charity may benefit from a deed of release, but I don't know that it brings any sort of closure to a forgotten Australian. I think it's again, you know, we'll pay you if you do this. So no, I don't think it's in the benefit of the forgotten Australian at all. And most people wouldn't want to go to court because, you know...
That was going to be my next question.
Yes.
There's a concern that's raised that, in fact, the redress payment might become the seed money for a common law claim. What's your response to that, if any?
Well, I think if someone wants to use that money to go to court, so, well, you know, so be it. But I doubt that. I think, and people have said today that it's not about the money, and in some cases it's not about the money, but it's the only thing that churches and charities and governments particularly can do to say sorry. I mean, they've said sorry, but nothing has changed in the lives of most forgotten Australians. They're still living below the poverty line. They've still got drug and alcohol issues. They've still got all the issues they had before Prime Minister stood up and said sorry. So,
my final issue is just the question of the standard of proof. You request that we recommend plausibility as the test. Do you think, just to take a significant leap up the scale to balance of probabilities, do you think that there would be many outcomes that would be different if balance of probability was adopted as opposed to plausibility?
I don't know. I'd have to really think about that.
I'm not suggesting that that's where we'll land, but
no.
I just wonder what your thinking, having spoken to many people,
Yes.
would be.
Most of the people that I speak to, maybe I'm naive, I believe most of what they say. So I don't think that would make a difference. But for some, I know people who have been knocked back because they couldn't remember the outline of the building that they were housed in, and they got knocked back for a compensation payout because they couldn't describe where the bathroom was or where the bedroom was. So, yes, possibly some people could be confused, and some people are in their 80s and beyond, so it is a long time ago. And as a child, things look very different to what they do today, so it could make a difference, yes.
Yes, you've heard perhaps that some of the decision makers have told us that very few people fail to recover under schemes which have a balance of probabilities test.
Yes.
Yes, thank you.
Just in terms of the example you gave, Ms Carroll, were those people seeking redress through a scheme that's happened in the past?
No, they went directly to the church.
I see. Thank you.
Could I just ask for a point of clarification? His Honour took you to your recommendation number 10, which is a guaranteed minimum payment of $10,000 to all survivors who can establish they were resident in an institution. I just want to be clear, when you use the term resident in an institution, does that encompass those that are in foster care within familial or other environments? Or do you draw a distinction between those that spent some time in a residential service, a group home of some description, when you make that recommendation?
No, it includes foster care as well. Yes.
And in terms of the 500,000 that you referred to in the Senate report, that figure, have you been able to do any work further or know of any work further that's been undertaken in relation to the number of people that were directly affected and are still alive yourselves?
Sorry, I don't...
Well, sorry, in our consultation paper, we've made a number of assumptions about the number of people affected.
Yes.
You've referred to the figure of 500,000 and you've identified that came from the Senate report. Yes. I was wondering whether you have independently become aware of any further work which gives a better estimate than either ours or the Senate's.
Well, the only thing I can say is that one of the organisations in Victoria said that on their books alone they had over 100,000 people. So it's quite a conservative number, the 500,000, when you think of a little state like Victoria had over 100,000 just in the group. It was a Catholic institution, Catholic homes. So.
Okay, thank you.
Thank you, Your Honour.
Yes, thank you, Ms. Carroll. Thank you again for all of your work on our behalf. Thank you.